Hello readers, reading of article written by C.A. Bimal Jain sir. Relevant provision for this article is section 147 of the IT Act. This section provides for income escaping assessment. If any income chargeable to tax in the case of an assessee has escaped assessment for any assessment year, the assessing officer may, subject to the provision of section 148 to 153, assess or reassess such income or recompute the loss or the depreciation allowance or any other allowance or deduction for such assessment year hereinafter in this section and in section 148 to 153 referred to as the relevant assessment year. Explanation to this section is for the purpose of assessment or reassessment or recomputation under this section, the assessing officer may assess or reassess the income in respect of any issue which has escaped assessment and such issue comes to the notice subsequently in the course of proceeding under this section irrespective of the fact that the provision of section 148A have not been complied with. The article is titled mere reason to believe do not satisfy the condition for reopening of the assessment, written by C.A. Bimal Jain sir. The article reads as the Honorable Bombay High Court in Pune Capital Private Limited versus the Assistant Commissioner of Income Tax and others, writ petition number 1091 of 2022 dated February 15, 2023, quashed the notice and the consequential order of the Revenue Department for reopening of assessment, held that the Revenue Department could only reopen an assessment beyond 4 years if there was a failure on the part of assessee to disclose material facts fully and truly and not on the basis of reason to believe without satisfying the jurisdictional condition required under the provision of section 147 of the Income Tax Act 1961. Fact of the case is Pune Capital Private Limited had filed the income tax return under the section 139 of the IT Act for the assessment year 2015-16. The Revenue Department selected the case for scrutiny and issued a notice under section 142 subsection 1 of the IT Act calling for the various detail mentioned therein. The petitioner replied to the notice submitting its financial statement for the AY 2015-16 and the assessment proceeding were completed under section 143 subsection 3 dated August 31, 2017, accepting the loss of INR 4,23,213 declared in the return of income. Subsequently, a notice dated March 31, 2021 under section 146 of the IT Act was issued by the respondent on the ground that there was a reason to believe that income from A for AY 2015-16 has escaped assessment as per section 147 of the IT Act. The petitioner, in response to the impugnant notice dated April 13, 2021, filed the ROI declaring the loss of rupees 4,23,213 and further requested for a copy of the reasons recorded for reopening the assessment, which was provided by the respondent. The petitioner raised the objection against the reason for initiating the reassessment proceeding, contending that the reason reflected non-application of mind by the respondent and were based upon an incorrect factual matrix, wherein the loan had not been taken by the petitioner but rather advanced to Messrs. Outstripe Suppliers Private Limited, on which the interest was also received, and details regarding the same were provided during the assessment proceeding. However, the objection were rejected by the respondent by the order dated December 14, 2021. Being agreed, this petition has been filed. Issue in the case is whether the reopening of the assessment is sustainable. The Honorable Bombay High Court has held in writ petition number 1091 of 2022 as under analyzed section 147 of the IT Act and noted that if the respondent had reason to believe in any assessment year that any income chargeable to tax has escaped assessment, the respondent may assess or reassess such income as well as any other income chargeable to tax which had escaped assessment and which came to the notice to its notice subsequently in the course of proceeding, subject to provision of section 148 to 153 of the IT Act. Further noted that if an assessment under section 143 subsection 3 has not has been made for the relevant AY, no action shall be taken under section 147 of the IT Act after the expiry of 4 years from the end of relevant AY, unless an income chargeable to tax has escaped assessment for such AY by reason of failure on the part of the petitioner to disclose fully and truly all material facts necessary for its assessment for that assessment year. Observe that the respondent has reopened the assessment solely on the basis of a reason to believe and not on the grounds of failure to disclose material facts fully and truly, which would have required satisfaction on the part of the respondent, particularly since the reopening pertains to a period beyond 4 years. Relied on the judgment in its earlier matter of Hindustan Lever Limited versus R.V. Wadkar, Assistant Commissioner of Income Tax, writ petition number 1504 of 2003, dated February 25, 2004, wherein the court set aside the notice issued under Section 148 of the IT Act on the ground that the Revenue Department had not stated that there was a failure on the part of the assessee to disclose fully and truly the material facts necessary for the assessment, without touching upon any of the other grounds, held that the respondent's manner of proceeding reflects a complete non-application of mind which does not satisfy the jurisdictional condition required under Section 147 of the IT Act, quashed the impugnant notice and the impugnant order. Thank you. Read this article by yourself. The article is titled Mere Reason to Believe Do Not Satisfy the Condition for Reopening of the Assessment. This article is available under article section. Thank you.